All right, with that, I'll call to order this other matters portion of the City of West Palm Beach's code enforcement hearing. It's October 1st, 2025. It's 11:33. My name is Amity Barnard. I'm the special magistrate for this afternoon's hearing. The first thing I'm going to do is swear anybody in who's here to testify on any of these items on this portion of the agenda. So if you're here for code enforcement, other matter, if you could stand if you're able and raise your right hands, and I'll swear you all in at once. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. You may be seated. With that, a little bit about process. When you hear your case called, city staff is already standing at the podium to my left there. You'll come to the podium down here to my right. City will go first and give me a couple of introductory remarks as it relates to the case, and then you'll get an opportunity in the fine reduction hearings to explain to me why the fine should be reduced. So with that, I'll turn it to the city to call its first case.
First case number 34-1743 Village Boulevard 203 CE 24041764.
Hi, Mark Joyce, City of West Palm Beach Code Enforcement. So come over to there. For 1743 Village Boulevard, case CE 24041764. This is a case for a rental license and certificate of use. We've come to an agreement prior to this hearing to reduce the lien to $2,000 payable in 90 days.
All right, your name, sir?
Harlan Miller.
And are you with Ramon Investment LLC?
I have the affidavit to represent them. They're an international owner.
Okay, great.
What is the name?
My name? Harlan Miller, H-A-R-L-A-N.
And you're the authorized agent, basically?
Yeah.
All right, and you heard the city's position. You're in agreement with that amount?
I am, but I would appreciate a short discussion if that's possible.
We certainly can. So I guess if that's his position, can you get your typical testimony on the record if he's actually not in agreement with that number?
Okay.
Let me have the city testify, and then I'll let you have an opportunity, okay?
Okay, the owners were ordered on 5/15/24 to comply by 5/25/24. Fine started on 5/26/24. It was a fine of $200 a day. They complied on 9/3/24, ran for 100 days for a total of $20,000. Yeah, normally the city would ask for 25% for the owner, but I spoke with Mr. Holland prior to this, and we came to agreement because there were extenuating circumstances to reduce the fine, basically 90%.
Okay. Go ahead, sir.
So, this is my first lien hearing, so it's more about information so I can be a better representative, I guess. I appreciate Mark, calling me and working out an agreement to the 10%. But, it did kind of seem a little bit extensive under the circumstance that the mother of the person that owns the property, who lived in Miami or in the United States, passed away in the month that this kind of all transpired. And I just wanted to ask if there's ever any latitude in the future. I'm not asking for it on this case, that if something severe like this happens, where a death happens, is there ever an opportunity to go below 10%? Because it seems like 10% is kind of a threshold. So I just want to have clarity on that because it'll help me do my job better.
Yeah, so I guess what I can tell you is my job here as the magistrate, there are some factors that are set forth in Chapter 162 of state law that give me things to consider in terms of reducing a fine, but ultimately it's the respondent's burden to show me why a fine should be reduced. The things that are named in this statute are things like the gravity of the violation, the efforts that the respondent took to bring the property into compliance. So that typically translates to how much money you've spent, what you've done to bring the property into compliance. The statutory factors have more to do with the property itself rather than extenuating circumstances. So, but I realize life happens, right? But that doesn't absolve someone of being responsible for code enforcement violations. So there is a balance there, so I'll tell you that there's no one-size-fits-all answer there. I'll tell you that my job as a magistrate and any other magistrate that sits in this chair's job is to consider the statutory factors and any evidence that you bring to a fine reduction hearing. So there's no blanket across the board. If somebody dies, does that automatically mean that my liens get wiped away? I'm not telling you that. I'm telling you that every one of these cases is a fact-specific analysis about what you've done to bring the property into compliance and what's happened in the case. So I know that's not the answer you want to hear, but that's sort of the reality. That said, any magistrate's job, even at this stage of a proceeding or in the violation stage, is to consider everything, consider the city's job in terms of getting cases to a hearing and find a balance between the two kind of competing interests. So
add a few more comments. So my number one, obviously, resistance is I don't want to obviously in any way compromise the agreement we've come to. So that's my first objective, obviously. So, if the magistrate agrees to 10%, then, so be it. But I did want to talk a little bit about this because I feel that for 9 years, this owner paid their business license for their rental license. They never missed a payment. Their mother passes away, their father passed away in the same calendar year. And the mail was going to their house. Like I said, this client lives internationally. Just in the grief and the chaos of losing two parents within a 4-month period, they didn't pay a $56 fee. There's no other violations. They have no, other code enforcement issues. There's nothing external that impacts the community as a whole. It's an internal thing. So with that, my debate with Mark was that, to pay a $2,000 fine, which is like a 400% penalty on a $56 thing over, a verifiable, I have death certificates and everything, that seemed a little egregious to me. Now, in the good grace of the city, if they don't feel that's egregious, I'm not here to argue that, but to me, that would be a reason why it wasn't impacting the general public, it wasn't impacting the appearance of the property or the deterioration of it. It was a lack of a payment that they had made 9 consecutive years on time. And so I felt that, $2,000 is fairly extensive for that when it was a $56 error. And it was really ultimately 100% caused by the loss of their parents.
So I certainly hear that. Let me give the city an opportunity to respond. Anything?
Oh, no, we have an agreement, so if, unless he wants to litigate this, then we could do that, but it's up to you.
Well, like I said, my only apprehension is I'm okay with taking the 10 because it's better than 25, but I'm at the mercy of the city having never been here I would absolutely want to fight for them to have a lower reduction under the circumstances because I do think that, again, they haven't done anything egregious to present to the city that they don't care, such as a maintenance issue or that. It was ultimately not paying a $56 fine. And so again, I have no vested interest in this other than that I just find it to be fairly excessive for something that happened like that, especially because they had a history of paying for 9 years in a row.
Yeah, and that's certainly the number of cases, code enforcement cases on a property is also certainly something that I consider in any fine reduction hearing. What I will say to your point about this not being visible to the public and outwardly visible in terms of the nature of the violation, I just will point out to you that doesn't change the fact that the city has had to spend money to get this case through a hearing. So that's also a consideration, at least from my chair, is that just because you can't see a violation from the outside doesn't mean it's a violation of the city's code. So I think it's probably in your best interest to go with the mutually agreed because that's lower than the typical 25% that I grant.
Okay.
I think that does take into consideration in this instance that this was the only case, but it does make the city at least give them the opportunity to recover costs that they've expended. I presume there's a lien recorded on this, so there'll be additional costs after today to release that lien. So they're not done paying hard costs in terms of this case as we sit here in this moment. So are you in agreement with the $2,000?
Yes, can you explain what other fees that they'll incur so I can explain that to them?
Yeah, so typically fine assessment orders are recorded in the public record as liens. So after this hearing, if there's a fine reduction, typically the next request is a release of lien, which the city then has to generate. I'm sure their legal counsel does that. There's also recording fees to record those releases.
Those fees are not those fees are absorbed by the city. So you just have to pay the $2,000 or the owners, yeah.
Yeah,
Okay.
I'm sorry if I confused you on that. Those are not fees that you're responsible for or the
Gotcha.
property owner's responsible for, but my point to you is that those are hard costs that the city is paying its legal staff and the recording department to process the case. So those are not your fees.
Well, I greatly appreciate, like I said, I'm just here to mostly learn and get better at my own.
Sure, and I
profession.
appreciate that inquiry. So with that, anything further from the city in this one?
No.
All right, in case CE 24041764, having heard the testimony of both the city as well as the respondent's representative, I will grant the agreed reduction. I'll reduce the lien amount from $20,000 down to $2,000 payable within 90 days. And she'll give you a copy of the order right there to her left. Thank you, sir.
Thank you.
Thank you, Magistrate and Mark, appreciate it.
Thank you.
Next case number 38-936 45th Street, CE 02020122, number 38-936 45th Street.
Okay, for 936 45th Street, CE 02020122. This was a case for fence maintenance and a permit, trash and debris, overgrowth, rotten wood, unpaid parking. I've spoken with the attorney for the owner prior to this meeting, and we've come to an agreement to a reduction to $10,000 and payable within 90 days.
Your name, sir?
Michael Marino, good morning.
Good morning. So you've heard what the city says. You're in agreement with that?
Yeah, we are in
reduced amount?
agreement, yes.
And you can pay that within 90 days?
Yes, 90 days should be more than enough.
Okay. All right, anything else you'd like me to hear?
No.
Okay,
just,
easy enough.
All right.
All right, in case CE 02020122, having heard the testimony of the city as well as respondent's counsel, I will grant the mutually agreed reduction and reduce the previous lien amount from $624,900 down to $10,000 payable within 90 days. And she'll give you a copy of that order right there.
Thank you, appreciate it.
Okay. Next case for 2300 Palm Beach Lakes Boulevard. We have 12 cases to read into the record. So it'd be number 30, CE 21020301, number 31, CE 17030133, number 32, CE 21030469, number 33, CE 21030442, number 35, CE 16090166, number 40, CE 20060222, number 41, CE 20010503, number 42, CE 20060177, number 43, CE 20060167, number 44, CE 20010488, number 45, CE 20060221, and 46, CE 23010320.
Mark Joyce, Code Enforcement. So for these 12 cases, only one case, number 30, was against the owner for an electric panel installed without a permit. Every other case was a tenant that had, BTR and COU issues. So the city has agreed to reach an agreement with the attorney for the applicant to reduce the 12 liens in total to $10,000 total payable within 60 days.
Did you figure out monetary amounts for each one? Because I presume you're going to need orders for each one.
We can do it as the total and then break it down after. We can do one amount.
And just read all the cases at once in one order? Is that how you'd prefer to do it?
Yes.
Okay. That's certainly simpler for those of us who are not mathematically inclined, like myself. Your name, ma'am?
Adriana Clemens.
And your counsel?
Yes, counsel for the property owner.
And you're in agreement with what the city has just said?
Yes.
All right. Does anybody off the top of their head know the total lien amounts for all of them
I
combined?
did not add them up, or I don't have the total.
All right, I will just read all of the case numbers then, and then note the reflected totals as they appear on the agenda, unless I hear any opposition to doing it that way. I think the order will be clear. It'll reduce it down to the number. That's the important part. Anything else you'd like me to hear, ma'am?
No, thank you.
All right. All right, so in cases, I'm going to rattle these all off again, and I'll do, I guess, a single order that reflects all 12 of these, but in cases CE 210-20301, CE 17030133, CE 21030469, CE 21030442, CE 16090166, CE 20060222, CE 200100503, CE 20060177, CE 2006067, CE 200104888, CE 200602221, and CE 230100320. I will reduce the total lien amounts in each case from their previous amounts to a total amount in all 12 cases of $10,000 payable within 60 days. And I presume you will have to get that order. I don't know if you have that ready to give her now.
Yeah.
Perfect.
Thank you.
Next, number 29, 801 37th Street, CE 11040531.
It's, number 39 is the same owner also. I don't know if you want to hear both of those at the same time as well.
Yeah, you can call them both if you want, and then I'll rule on them separately.
Number 39, 809 37th Street, CE 24021437.
Okay, yeah, these are both contiguous properties, one right next to another, and both owned by Mr. Moody. Okay, so for 801 37th Street at CE 11040531, it's number 29 on the agenda. It was cited for overgrowth, debris, and a visibility triangle. It was ordered on 8/31/2011 to comply by 10/31/2011. The fine started on 11/1/2011. It was a $100 a day fine, ran for 297 days. The current fine is $29,700. The comply date was 8/24/2012. The city is offering a 75% reduction to $7,425. For 809 37th Street, number 39 on the agenda, it's CE 24021437, was cited for overgrowth, clean and sanitary, hedges, obstructing the right-of-way, trees or hedges obstructing the right-of-way, outdoor storage, fence and wall maintenance, address characters, paint, swale and parkway, and trash cans in public view. It was ordered on 4/3/24 to comply by 7/2/24. The fine started on 7/3/24. It was a $100 a day fine, complied on 12/20/24, ran for 170 days for a $17,000 fine or lien. The city is offering 25%. It's the same owner. 25% reduction to, 75% reduction to 25% of the lien, or $4,250.
All right, your names for the record?
Glenn Moody.
And your name, ma'am?
Catherine Canich.
All right. So we'll start with the first one, 801 37th Street. You've heard what the city is saying. What's your position?
Yes, so the original citation was for multiple violations, and the visibility triangle, I don't, so the visibility triangle was cited, which it was actually in compliance. The two, it's a corner of our property.
Well, let me interrupt you there, Mr. Moody. I just want to be clear. This is a fine reduction hearing. So what I'm interested in hearing is why the fine should be reduced.
Okay.
It sounds like you're contesting whether there was a violation.
Yeah.
And this is not the appropriate place to do that.
Okay, well, so the Officer Houghton, told me that when I was in compliance, I would be, the fines would be zeroed out. But she wouldn't comply because of the leaves, which every day during the fall, when the leaves are falling, I get up to 3 trash bags a day that I have to take. So I was like in a catch-22 situation where I couldn't comply with her. So I said, so after all these infractions, like she had me tear down a 30-plus-year-old shed, paint the house, tent for termites, which I had done just a few years earlier, and they came on the property, which I didn't realize was not allowed, because you couldn't see the shed from I was there for 26 years, but this was like 30 years before that that it was built. Anyway, when I walked with her through it, I said, so you're not complying with me because of the leaves? She said, yes. And then I came to the hearing. She met me at the entrance and said, you are in compliance. We will zero out the fines. And that's a promise she made, zero out the fines. And
when you're saying the hearing, you mean back in 2011?
yes.
Okay.
And then I also came to a hearing, and the fines were still running way after it was complied. Like the fines that she was talking about was just, since I missed the hearing, I had to have another hearing, so it was like less than 2 months, maybe even 1 month, that I came to the hearing, and she said it was in compliance. So I should only have to zero out just 1 month's fines. And the second case,
Let's stay on this one,
Okay.
just while we're on this one. So this one, the city is telling me the fine ran for 297 days. Do you have something in writing from the code enforcement officer showing that she complied the case out prior to August of 2012?
Nobody ever gives me anything in writing. I just take them at their word. When I'm complied, they tell me. They never give me anything in writing. It's not been an issue until that point.
Do you have evidence with you showing me when you complied the property?
Do I what?
Do you have evidence with you on when the property was in compliance?
Well, if it's the visibility part, like she was not complying me because of the leaves, and I blew all the leaves when it was just when he just did the Officer Joyce did the excuse me, the inspection. There were leaves just from the day overnight, but it wasn't an issue. So it was out of compliance because of the leaves, and also the visibility triangle. The property is curved like this, so the triangle starts actually in the road. There's a
Yeah, that you're getting into an issue of what the violation was or wasn't, and that's something you had to deal with prior to today. What do you think the fine should be reduced to?
Well, on that one, I think it should be zeroed out.
But I just want to say, when you say on that one, what do you mean on that entire case?
On the one we're talking about, 801.
Okay.
Because, I mean, she's a city worker, and she promised that to me, that they would be zeroed out. I never even heard the term zeroed out until she told me that.
And you don't have anything in writing?
I do not have anything in writing. It's just talking with her.
All right. What's the city's response?
I spoke to Mr. Moody prior to this hearing also, just like the rest of the applicants, to try to negotiate with him. But, and he said the same thing to me, and explained to him there would be nothing to zero out when you're walking into a hearing. A fine would not start until after the hearing, and at the hearing they would give you X amount of time to comply. In this case, it was like 60 days, and then a fine would start. So there would be, so I think it might be confusing something, because the fine doesn't start till after the hearing. Wouldn't be nothing to zero out.
Okay, well, I'm not sure of the particular dates, but it was, I don't have that in writing about the particular dates but.
Are you trying to sell the property?
Yes.
Okay, so that's what you're trying to get rid of the liens. What did you do to bring the property into compliance? Explain to me what your efforts were to get complied here.
On this case?
Mm-hmm, on 29.
Well, the officer came out on the visibility triangle, and I had been cited before on that, and I explained, I even painted on the sidewalk where the visibility triangle was, because it starts way out in the road because of the sidewalks here, but it starts out on the road. So you measure from that point. But so it was in compliance, and they came out and agreed with me, so they complied it. As far as I know.
That was in August, right, of 2012.
I don't have a calendar.
Yeah, that's what the city's telling me, so I don't have any reason to dispute that that's the compliance date.
But I'd had that before, and so this time I actually taped it off and painted it and measured it for him. It was in compliance. It wasn't out of compliance. So
let's go to 39 before I rule on 29. Let's switch to 39. So in that case, it looks like there was a whole bunch of violations, but in that case, they only ran for 170 days.
Right.
What's your position on that one, Mr.
Okay.
Mooney?
Okay, you heard this case before with Mrs. Weaver, Officer Weaver. I couldn't get her to come out before the hearing, and I had complied completely. I just bent over backwards getting the case complied, even better than it had ever been before. Everything was trimmed, and previous code officers had complied it. When I had a complaint, like, during a storm, a branch comes down, and then an officer comes out, if I'm on a vacation or whatever, and also it's a xeriscape landscaping, so it's environmentally, it's a sustainable property. So we just talked on the phone, and I couldn't get her to comply it, and I worked on the place. Well, that's besides the point. At the hearing, when I talked to you about getting a different officer, because I knew she was lying, because she had told me that there weren't really any complaints, and she was kind of vague about it. But when she made the case, she said that they're under oath. She said that this property was originally called in as a complaint. That was on the hearing, was minute 3617.
So again, you have appellate rights under the orders. You're getting into what you think was wrong with prior hearings. That's not today's hearing. Today's hearing is why should I reduce the fines?
Okay.
If you had a problem with the order that was issued, you have rights to appeal that order within a specified time. my job today is not to relitigate those cases. That's not appropriate for me to do today. My
Okay.
job today is for me to listen to what you did between that hearing and today, what efforts you took to get into compliance, and
Yeah,
why
I
the
did-
fine should go down.
Okay, I did, she kept adding things after the hearing. She added changing the number on my cottage. She added taking off, on the swale, there's a walkway that was, had two pavers there. She added that to take it off. That wasn't in the original citation. She also complied the house, but there's a downspout that puts dirt on the property, so she complied it for painting, and then she took that off. It was just a cat and mouse game with her. It was.
But what I'm not hearing is, what did you do, sir? Not what did the city do?
I did the painting.
Okay.
I did everything she asked every time. And then she came out a second time, brought Officer Robert, is it Watkins, out to the property. She said, do everything he says to do, and then it'll be complied. So we did that. It took about a week. He added a couple more things to the list, and it went back, and she refused to comply it. She gave me a new list, and I was at my wit's end. It was just crazy, and we did everything each time. It took like 9 months before she was on vacation, and the next inspection was up, and Officer Robert came out and complied the property in December. And
So the city's telling me the fine ran for 170 days, so that's less than 6 months, correct?
Yes,
is it less than 6 months?
yes.
So,
It seemed like having a baby, so I guess 9 months was close to it.
right.
But this is, I've had to request, mental health and lose sleep over this, and at the hearing I requested another officer, and Officer Joyce said he couldn't do that, but because the other thing she did, we were trying to get in compliance. She had said to us, we don't have to do any other cutting except cutting the tree that was wind damaged and cut back. So it was a damaged tree. I cut that out, and then she came back and said, you have to cut everything on the swale that is not a tree. The cycads, beautiful Kunti native cycads, and so she kept adding these things to the list. That took like a month, digging up these huge.
Did you do all the
cycads.
work yourself, or did you hire somebody?
I did myself. I had someone help me volunteer, but yeah, I did it all myself. I'm at my income with the rent and the insurance and the taxes is below poverty level. It's like last year it was, with the rent, it was like $24,000 a year.
Okay.
This
What do
is
you
just-
think this one? What do you think this fine should be reduced to? The city has offered you down to 25%.
Well, that one I wanted to have it thrown out because the officer was lying to us. She
But
lied to you under
That's not
oath.
this process, sir. That's you would have needed to file an appeal. The fine reduction hearing is not the time to do that. I can't relitigate the case here today. That timeline, I believe, is probably passed, given the date that was given to me by the city. But challenging the order altogether this is not the place to do that.
Okay.
The place,
I would,
what you need to do here is ask me to reduce the fine. So,
okay. That's what I was asking, but I mean, I don't know how, you know, even if it was, you know, if you had me a fine for that for $5,000, it's still a lot for me with my income. And I think, you know, the officer it was like she had, I'm so confused that it was like she had a personal vendetta against me, maybe because I told you that I didn't trust her.
Well,
during the
let me
hearing.
ask the city, how many cases has this respondent had before code enforcement?
She's checking now.
Okay. Do you know, sir, how many times you've been to code enforcement in the city?
I usually get a code citation when the officers change. So it's maybe 5, well, it's different cases. See, this one was done on 809, but she included 801.
So
that she wanted
801
me
had
to do.
5 cases,
5 on 801.
and
It's basically the same property.
It's usually overgrowth that we wind up citing him for. I mean, you've seen some of the photos that have popped up. The property gets really overgrown, and I understand he's saying it's xeriscape, but some people think that means no maintenance.
Yeah.
But it's not really that, and you have to maintain a property even with xeriscape, and so every once in a while we have to go in and ask Mr. Moody, can you get this stuff cleaned up, so, but it's the way it is,
okay, 801. Let me see about 809.
So 5 on 801, and how many on 809?
Let me check. Yep, right now I'll tell you. Go back.
Usually the but I've been a supervisor myself. If one of my employees did this, I would have fired her. I'm not saying you should fire her, but if she does it to other people.
I really don't appreciate the disparaging remarks on my...
Yeah, what I'm interested in is your testimony about what you've done to comply yourself. I'm not interested in hearing allegations about anybody in the city.
All right.
That is not this hearing. This hearing is what did you do to come into compliance, and what have you done since those hearings to get yourself out of code compliance trouble?
809, it was 30 cases.
So, sir, you had 30 cases on 809. That is not, that you're a repeat code enforcement offender at that point. That's a significant number of cases.
Okay.
So, you're telling me about problems you had with one code officer, but this would suggest that you have had a problem with quite a few code enforcement officers if you've had 30 cases. So, again, let's go back to 29. The city has agreed to reduce the lien from $29,700 to $7,425. What amount are you suggesting that I reduce that lien to, knowing that you have 5 cases on that property?
That's the 801 or
Yes.
809?
801.
801. 801, 7,000. Would you be able to reduce it to 3,000?
All right, in case CE 110405331, I'm going to reduce the prior lien amount. How much time do you need for both of these cases? How much time do you need to pay? Are you under contract?
I'll be doing it this month, probably this week, so.
So I'll give you 60 days just to make sure.
All right.
Because just so you know, if the amount that I reduce the cases to doesn't get paid within the time I specify, it reverts back to the original amount, and you can't come back
no problem.
for further reduction. So in the first case, CE 1104053 I'm going to reduce the lien amount from $29,700 down to $4,500 payable within 60 days. And that's after having considered the testimony of both the city as well as the respondent and the number of prior cases in his efforts to comply the case. So let's go now to 809 37th Street. That one, given the number of cases, I'm inclined to grant the city its amount, which is the $4,250. That's a significant code compliance issue at that address. I know these are kind of related, so it's basically 35 cases, I guess, on the same property, but that's a lot of code enforcement over the years. I don't know how long you've lived there, but it's rare to hear a property that has that many cases over the tenure of an owner. So anything else you'd like me to hear on that one before I make my ruling?
What amount were you suggesting on that one?
The city's asking me or requesting that it be reduced to $4,250. So that's down to 25% of the original amount. That's a 75% reduction.
Is there, can I get 10% on that? That's a lot of money. I mean, I'm already paying $4,500.
All right, in case CE 24021437, having considered the testimony of the city and of the respondent in his efforts to comply the property, but noting that there have been 30 prior cases on the property, I'm going to reduce the lien amount from $17,000 down to $4,250 payable within 60 days. So she'll give you copies of both of those orders right there, sir, okay? Best of luck to you.
Thank you.
Thank you.
Is that it on fine reductions?
Yes.
All right, so do you want me to adjourn this portion of the hearing at 12:14 and we'll reconvene for the 12:30?
seconds, please.
All right, with that, I will call back to order the 12:30 hearing for the City of West Palm Beach, other matters agenda. My name is Amity Barnard. I'm the special magistrate for this portion of the agenda. First thing I'm going to do is swear anybody in who's going to be speaking on any of these items. So if you're here to testify on any of these items, if you could raise your right hands for me, you're already standing. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And a bit about process. Typically, the city will present its case first, and then I believe you're probably here. I'm not sure if you're here for the first one or both. It looks like they're the same, so you're probably here for both. So you'll hear their presentation. I'm not sure if they're going to split them up or not, but they'll go first. You'll go second, present any evidence you have for me, cross-examine any witnesses that the city puts on, and then at the end of that, I'll make a final ruling. So with that, I'll turn to the city to call its first case.
I assume we want to call the earlier violation first, so that would be 37 PD 25080451.
Is that on the July 26th?
Yes.
Okay. So basically, while on patrol, we conducted a routine business check on the business at 525 Nottingham Boulevard.
I'm sorry to interrupt you, sir. Can you give me your appearance, just so the record is clear? What's your name?
Oh, Lieutenant Craig Davis.
Thank you.
ID 1492 with the West Palm Beach Police Department.
Thank you, sir.
All right. Being currently assigned to Patrol Division, like I said, we did a routine business check on the business. As we saw, there was numerous patrons inside, numerous patrons outside, and the business appeared to be open, which would be after hours, as it was 4:03, which it was supposed to cease any type of alcohol sales or consumption at 4 o'clock. I went inside the bar, which of course was clear and obvious that they were fully operational. Staff behind the bar, currency exchange occurring between patrons and the staff, as well as numerous patrons inside consuming alcohol. I made contact with the manager on duty, who was identified by the staff, Mr. Jesus Loreno, and advised him of the ordinances. He actually was under the assumption that he was able to stay up until 5, which he was told he was not. I reviewed that information with him and basically documented the incident, and my body camera was activated during the contact.
Thank you, Lieutenant. And this occurred at 525 Nottingham Boulevard, is that correct?
Correct. El Bonche Bar.
An El Bonche Bar at that address is outside the downtown master plan area, is that right?
That is correct, sir.
Okay. And when you were there, we witnessed, I know you have a photo attached that we saw, and then you have body-worn camera also, and you also observed the consumption, selling, or service of alcohol at after the time that is allowed by code, is that correct?
Correct.
Okay. All right, thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence.
And just a note, once they were notified, they complied, and they shut the business down, and they closed all sales at that point.
Okay. And I guess a question for the city attorney, what do you need on the record in terms of notice for today?
212 Westwood.
As far as notice, I guess,
Show me out at 525.
Lieutenant Davis, you issued a notice. Did you issue a notice to appear?
No, sir. The current procedure is we just documented the incident, and we present it to code. Code enforcement then makes contact with the business owner, and then serves them with a notice. We choose this platform mostly because we were having incidents where we were notifying the staff, and they would not relay that to the business owners.
Let me ask you to hold on. Let me ask if she can stop that video. I don't know how did it stop? Okay, sorry, go ahead. It was getting louder. Go ahead.
So, I was just saying that we tend to have code enforcement notify the property owner now. That is the standard procedure we use now, because we were having too many incidents years past where if we notified staff, they would not relay that information to either the owner or the property owner. And then a lot of times we'd have these owners and people come in like, what are you talking about?
So when, sorry, man.
Go ahead.
So when you worked with code on collaborating, providing notice to the property owner, is it your understanding that they posted the notice to the property, posted notice at City Hall, and also sent certified mail notice to the property owner?
Yes, sir.
Thank you, sir.
And I also believe they reached out to the owner too, personally, so.
Okay, thank you.
All right, and I guess I'll take a look, maybe there are notice documents in the case file, but as she's doing that, do you want to restart that video? Give me your appearance, sir.
Yes, Attorney Alberto Leal on behalf of El Bonche Bar.
All right, have you seen the documents in this video, or do you want her to restart that?
No, that's okay. We don't have a factual dispute as to what went on. My client is interested in just resolving this matter. Sergeant Davis has been very forthcoming and cooperative in terms of working with us on that front.
All right, and what was your last name again? I'm sorry, sir.
Leal, spelled L-E-A-L.
Thank you. What is, before I have you proceed, what is the city's request for remedy in this case?
As far as the police department, as I said, we're just looking for compliance, education and compliance. As I said, when I did speak to the bar manager, each time they were just unaware of the ordinance and the statute, but they did comply once they were told.
And if I may, Special Magistrate, this, under 613 enforcement under this section, the city is requesting a one-time fine of $500 per violation.
Okay. All right, so with that, I guess, Madam Clerk, can I see the citation again? Yeah, that first one there, yeah, the police, I guess that's the police report. So this was on, you were out there on what day?
There was 2 incidents. One was on the 26th of July, and the other one was on the 1st of August.
So the first one, because the code is different days of the week. So what, this first case that we're talking about now, number 37, what day of the week was that, and what time were you there, is what I'm trying to confirm.
You would think they'd put that in the CAD report. Hold on a second, let me just check my phone.
Well, it's a Saturday, but I don't know what time.
I believe they both were on Saturday, but let me just verify. 7:26, yeah, so that would be a Saturday, early Saturday morning, or a late Friday night, if you want to look at it that way, whichever way they do. But it was an early Saturday morning.
That's sufficient. I just wanted to make sure that I understood, because I can't tell from the dates what day that was, and the code is specific about days of the week. Okay.
August 1st would have been a Friday morning.
Sure. All right, and then are there any other, I guess let me see the rest of the documents if I could in the case file. And I presume the city is intending to enter this case file into the record?
Yes, please.
All right, that I need to see as well. Okay. Okay. Same thing for today, okay. That's what I'm looking for right there, okay. All right, and the city's code, is this I'm not super familiar with this section of the code, but it allows for, 613 allows for a one-time fine. Does it matter what offense it is?
So the city's position is that it doesn't matter under 613, under this section of our code, which offense this is, but my understanding is that this is their first and second offense on these two cases. And yeah, under 613, we're just asking for a $500 fine on each case.
Okay. All right, Mr. Leal, any objection to the documents that you've seen on the screen being entered into the record, including the video?
No, Special Magistrate. As it applies to the fine, though, I do just want to make the City Commission aware that we're dealing with a small business. The individuals that own the business culturally are a little bit disconnected in terms of how things work here, as per the officer's testimony. They did comply right away. $500 fine per incident would equal $1,000. It's a bit steep for them to pay. Is there any wiggle room, any way we can negotiate that down?
Well, this is certainly the place to have that conversation. I guess let me ask the city attorney, does the code mandate that fine amount? Can you read me 613? I don't have that in front of me.
Yeah, in pertinent part, the 613 states that unless otherwise specifically authorized and provided by law, a person convicted of violating this article may be sentenced to pay a fine not to exceed $500. And it goes on to say, and may be sentenced to a definite term of imprisonment, but we're not in a criminal proceeding here, so that's not at play.
So,
Okay, so the 500 is a not to exceed amount, and there's discretion.
Yes, that's
would appear
correct.
on my part as it relates to that fine amount.
Yes, ma'am.
Okay. All right. Mr. Leal, would you like me to hear the testimony in the other case before I rule, or would you like me to rule on this one first?
It's up to you, Special Magistrate. That's fine if you want. I don't think the testimony is going to be too different from what you heard, but that's okay. If you think it would be more expedient to do it that way, we wouldn't have an objection.
Yeah, let's go ahead and do that. Just because I'm sensitive to the comment that he just made, if this is in fact their first and second offense, I don't discount the gravity of the violation, but let's go ahead and have you testify as it relates to case 36, if we could have that one called in, and then I'll hear all that, and then I'll rule on both separately at the end.
That's for PD 25090452 for the August 1st violation.
Okay. So once again, while serving in patrol duties, I drove by the residence, or excuse me, drove by the business. Again, saw it was appeared to be open for business with patrons entering and exiting the establishment. I entered the establishment. I made contact with the once again Mr. Jesus, who I'd made contact with previously. As I walked in, once again, staff was behind the bar. They were still exchanging currency with customers. Customers still had possession and were consuming alcoholic beverages upon my entry. I again made contact with Mr. Jesus, like I said, advised him of the ordinance, because at this time it was 3 a.m. because it was a Friday morning going into from a Thursday night. Once again, he was not aware that the time had changed, and he complied with the instructions to stop the business, in which he did. And once again, I notified code of the violation, and they proceeded to notify the owner.
Okay.
No further questions for Lieutenant, or no questions for Lieutenant Davis at this time, but the city would like to move this case file. I think we may have addressed this on previously, but just to be safe, move this case file into evidence, barring any objection.
All right.
No objection.
All right, thank you. And Madam Clerk, if I could just have you buzz through all those documents just so I can look at everything. Okay, timestamped, okay. Yeah, can you pull that little thing forward and get us inside, I guess? Oh, maybe not.
No, it starts here in a second.
212 Westbrook. Chauvet at 525 Nottingwood.
If you click on the bar, it might move forward. If you just try clicking on the bar. No, go a little further.
Doesn't seem to want to fast forward.
Keys. Buried. Over in my pocket. That's me.
All right, that's sufficient. Counsel, do you want to watch the remainder of that?
I don't have to.
Okay. That's sufficient for me. The patrons are clearly being served, and the dates and timestamp there are after the prescribed hours in the code. I guess what I need to see is the notice document, the notice of violation, and the affidavit. Okay. All right, sir, you said no objection on this case file being entered?
No objection.
All right, thank you for that. And the city's request on this one is the same $500 fine one time?
Yes, ma'am.
All right, Mr. Leal, anything else you'd like me to hear on either?
Well, just a quick reminder, Your Honor, that, this is a business that's very small in nature. I think we saw from the video, it's basically a standalone shack, for lack of a better term. They don't have a whole lot of resources. It's been very burdensome. I'm doing this on a very low-cost basis for them just to help them out. Essentially, what they would be looking for, I think they're okay with the idea of having to pay a fine because they understand that, at the end of the day, they do have to comply with municipal code. But again, I think $1,000 total, $500 per violation is a bit steep for them. So we would, at the very least, be asking for the magistrate to consider to cut that in half, if at all possible.
Have there been any additional instances after the August 1st date?
Not to my knowledge, no.
Okay. Does the city have any information on that?
Nothing directly on the property, no, ma'am.
Okay, so no additional violations for the same thing. There's not 10 more of these coming to the next month's hearing?
No, ma'am.
Okay. All right, anything else from the city on either case?
No, Your Honor.
All right. All right, with that, I will start in case PD 2509-0452. I'll enter the city's evidentiary case files composite Exhibit 1 without objection. I'll find, based on the affidavit of posting in the case file, that the city had good service for today's hearing. I'll find, based on the testimony of the lieutenant, as well as the documents and video evidence in the case file, that the respondent was in violation of Section 6-4-B for consumption, sales, service after the prescribed hours based on the location of the establishment. I'll impose a one-time fine for this instance, which was the August 1st date, August 1st, 2025 date, I'll impose a one-time fine of $250 for that violation. Does that need to be payable within a certain time?
There's no time restriction
So just a
on
one-time
that
fine is
payment.
fine?
Yeah.
Okay, so we'll just leave it at a one-time fine on that one. And then in the second case, PD 2508-0451, I will again enter the city's evidentiary case files composite exhibit 1 without objection. I'll find again, based on the notice documents in the case file, which include an affidavit of posting, that the city had good service for this morning's hearing, or this afternoon rather. Again, based on the photographs and the video in the case file, I will find a violation of 6-4-B for the same consumption, sales, and service after the allowed time in the code. And for this violation, which was for July 26, 2025, I'll again impose a one-time fine of $250 for that violation. I've done what you asked, Mr. Liao, because I think you're right if this is a first and second violation, but I would tell you to bring back to your client that there will not be the same leniency if the violation repeats and the pattern repeats. So as long as behavior has changed and they're working toward compliance with the code, I'm fine to not be as punitive, because that's not my job here. It's to ensure compliance.
Thank you. We appreciate that. And so I know there's not necessarily a timeline for them to pay it by. It might be easier for them to pay one this month and then one the following month.
That's fine. The order won't say a specified time. Just make sure they clean it up, because if they don't get it paid, the city may file it as a lien against the property. So it's in their best interest to pay it sooner rather than later, just so it doesn't become a lien.
Absolutely. Will they receive notice of that order, or will I get a copy today?
They will get a copy. The city will send a copy of the order.
Okay, yeah, that would be fine.
Okay, great. Thank you, sir.
Okay. Thank you so much.
Thank you.
All right, is that it for today? All right, with that, I will adjourn at 12:53.